A lot of people ask me, how hard is it to get a patent? And the answer is, it's time-consuming, but very achievable. The standard in the Patent Office for getting a patent in the US, the bar is something that can be done. There are certain requirements, though. Your invention and the patent application must be for an invention that is useful, novel, and non-obvious. If it doesn't meet those categories, the Patent Office will not grant the patent. Useful means it's in one of the accepted categories, for example, a machine, a process, or system, and not in an excluded category, such as an algorithm or a recipe, something like that. Novel means it's new. People haven't done it before. When people ask me, should I file a patent application for my invention, I often ask them, well, did this solve a problem you had, and were you unable to find anything to help you solve the problem? If they say, no, I had to come up with my own solution, that's typically evidence of novelty. Now, non-obvious is something different. Sometimes people just change an idea slightly. They may change the material that something's made out of, they may just change the size of it, or they may change the color. Typically, those things alone won't make a new invention. They might, but typically they don't. So you have to look at substantial change to what has been done before. So if you're thinking about a patent application, make sure it's something that's useful, new, and non-obvious. When people think about intellectual property, they often confuse patents, trademarks, and copyrights. A copyright is very straightforward. A copyright protects a particular expression of an idea. That may sound a little too legal, but let's talk about it. Let's consider the idea of two families with children that fall in love, and the families don't want those children to be together. That same idea is found in two different stories, Romeo and Juliet and West Side Story. Those are two different expressions of the same idea. Both would be entitled to their own copyright as unique expressions of that idea. Now, the best part about copyright is it's free. Copyright exists the minute you create a work. The government considers the copyright to exist from that moment. You do not need to register your copyright. In fact, you don't even have to put the little C in a circle on the copyright, although I think it's a good idea if you do. But if you fail to do so, you aren't risking your rights. So there really isn't much you have to do for your copyrights to be protected. So you can register your copyrights later on if you feel the need to get protection or need to sue somebody on your copyright, but you don't have to. So remember, the best thing about copyrights is they're free and they exist the moment you create text, words, pictures, film, art, music, or software. A lot of my clients ask me, what is a patent? Because they are told that they should protect their inventions. A patent is a legal document issued by the federal government in Washington, D.C. that provides protection for an idea. The notion of patents is so important in this country and was so important right from the start that patents are specifically mentioned in the Constitution. A patent is, as I mentioned, is issued by the United States Patent Office in Washington, D.C., and its coverage extends to the borders of the United States. A patent, however, does not give you the right to do anything. A patent only gives you the right to stop others from making, using, or selling the patented invention. So even if you were to get a patent, you might not be able to make the product that you have patented. It may be covered by other people's patents, but it would give you the right to stop others from making, using, selling, even importing the invention. You can extend your patent to the borders of the country and stop other people from bringing products in that would infringe your patent. A patent is not a form. It's something that is examined by the U.S. Patent Office, and a determination is made if the patent should issue. It's an original writing, usually done with a patent attorney, although you can do it yourself, that tells the story of the invention in a way so that someone could make the invention using only the patent as a guide. You're not required to describe every technical idea in science in your patent. You're able to assume that someone knows a little bit about science or a little bit about your invention. However, you are required to reveal everything that makes your invention work. You can't keep any secrets when you communicate with the patent office. If you do, you run the risk of your patent being held invalid. After the examination at the United States Patent Office, if they agree with you that the patent should issue for your invention, a patent will issue, and you will have the rights to stop others from using your invention for 20 years from your original filing date. So if you think you have an idea, you should think about getting a patent for your idea. People, when they have a product, get confused as to how a trademark works. A trademark is simply an identification of the source of goods or services. It's not the product itself, it's the source of a product. For example, Tide laundry detergent. Tide is the maker of the laundry detergent. It's not the actual detergent itself. Although often trademarks, people come to identify them so closely with the product, they may substitute the name of the trademark for the product, but it's supposed to be a brand and represent the source. You obtain trademark rights from actual use in commerce or by registering your trademark with the United States Patent and Trademark Office. You can register your trademark, what's called an intent to use, or ITU, trademark application before you have any sales, when you've just thought of your idea for a name, for example. Many times people register their trademarks in advance before their product is fully developed or before they're ready to do sales. In fact, people will often check online on the intent to use trademarks because they are publicly available to see what other companies are doing. In fact, the Apple stores were known before Apple announced them because they had several trademarks on file for intent to use for Apple Store and other names related to the store. It's a good way to keep track of what your competitors are doing. The best trademarks that you can make or file for are arbitrary and don't have anything to do with the product itself. For example, Apple is associated with computers now, but an Apple itself has nothing to do with computers. Kodak, associated with film very strongly, but Kodak was a made-up word that the creator of the trademark felt had a strong name and strong sound, and so used that as a trademark. A trademark such as Microsoft, although a world-famous trademark, is not the strongest trademark because there are a lot of companies that have micro blank or blank soft in their titles because it's not arbitrary. It really is associated with the product itself. So if you are going to have a trademark for your company, you can do it in advance, and you should think of a name that is arbitrary and doesn't describe the product so closely.